now in the Chief Justice Court. Key among critical questions to be resolved are the troubling claims of attempted assassination on the special prosecutor. Not once, but twice. And the mystery surrounding why these incidents were never formally reported. What becomes of the special prosecutor after the Interior Ministry's investigation is completed? What would happen? In Parliament also, another storm is brewing over the declaration of a vacant seat in the Kpandai constituency that led to a chaotic scene in the chamber. The opposition MPP have strongly condemned the Tamale High Court ruling ordering a rerun of the Kpandai parliamentary election, describing it as a constitutional abomination, flawed and reckless. Will the MPP participate in the December 30 rerun? And why is the party insisting that notifying the Electoral Commission of the vacancy violates Article 99(2)? Well, this morning, my legal analyst and my political scientist in studio will help unpack these tensions. And beyond our borders, West Africa is indeed facing some tough times, with the recent wave of military takeovers in the sub-region. Is West Africa sliding towards a regional state of emergency? This is Current Agenda, the trusted Saturday morning companion. As usual, this is sponsored by Bank of Africa. Bank of Africa understands that we all need some financial quick fix every now and then, whether it is school fees, replacing that old refrigerator, or fixing the car engine to be back on the road. Bank of Africa's quick fix loan was made with you in mind. Seize the opportunity and let your tough times make way for that soft life you've been dreaming about. Visit any Bank of Africa branch near you today and enjoy unbeatably low interest rate, flexible terms, and straightforward application process. Call Bank of Africa on 0302 429 333 or 0302 249 690, or chat with Fafa at www.boaghanainfo.com for all the information you need. Remember, terms and conditions apply. Bank of Africa as strong as a group, as close as a partner. The National Petroleum Authority says that if you suspect you did not get the right amount of fuel, if you suspect that, if you have concerns or you have issues with the quality of fuel you bought, or if you experience bad customer service at any fuel station, don't stress, don't argue, don't fight your own way. The NPA is here to assist you. Reach out to their call center on 0302 550 380. Or feel free to walk into their head office, which is located along the Jowulu N1 highway, or any of their regional offices to make a complaint. Or if you want to make an inquiry, visit any of these offices. Remember, if you experience any of the issues I mentioned earlier at any fuel station, you have 48 hours to report it. NPA, where customer care meets excellence. Right back after this break, where I'll take my reflections.
For decades, we have helped businesses connect with their trade partners all over the globe. From Ghana to Burkina Faso, Côte d'Ivoire, Benin, Togo, Senegal, China, Morocco, France, Netherlands, and many other countries. We have made it possible to bring Ghana to the world. We have brought small and medium businesses closer to their customers across the regions in Ghana with our SME support facilities. We have brought relief and smiles to the faces of families with our employee personal loans. With our cutting-edge technology and digital support, we take the burden of complex thinking off you, making life simple. That is who we are. as close as a partner. Bank of Africa. We are indeed the African bank with the global reach.
Welcome back, and I'll have my reflections this morning. As usual, I would be speaking on a topic dear to my heart and which is also supported by one of our cherished viewers. I'll acknowledge him at the end for his input into this discussion. But this morning, I would want to speak on an interesting topic, something I term if Ghana treated public service like football management. If we treated public service like the way football owners or club owners treat management, treat their coaches, treat their managers, what would we be? Can we finally get results? Now, football fandom is very fleeting in nature. Over the week, and pardon me for using an international experience, over the week we've heard Liverpool fans asking for the swift dismissal, asking for the head of Ancelotti. After winning the title, the fans have become unforgiving. The world of football, the modern world of football now is very unforgiving. Yesterday's hero can quickly become today's scapegoat, as a few missteps erase memories of past glory. You can be a hero in May, but a liability by December. I repeat, you can be a hero in May, but a liability in December. The beautiful game is a results-driven business where performance is paramount and sentiment is a luxury few can afford. Now imagine if Ghana's public service worked with even a fraction of that energy I'm talking about. In football, everyone knows that the rules imply if you deliver, you stay. Deliver, stay. If you underperform, you are politely shown the exit before the next transfer window. It may be ruthless, yes, but it creates one thing Ghana's public service often struggles with: accountability. Imagine for a moment, and just take a moment as you listen to me, and imagine that our public institutions were run with the same performance culture. No political installation, no mysterious appointments in confidence, no recycling of individuals who have delivered little beyond loyalty. Just a simple, transparent equation: results or replacement. R or R. Deliver results or get replaced. It sounds harsh, I agree, but it's precisely why football attracts the best managers and maintains a certain pedigree and standard. Everyone understands that achievement matters. The incentives are aligned and the expectations are clear. The system is wired to protect the interest of the club, not the comfort of individuals. Ghana's public service is often plagued by a culture of complacency, where performance reviews are just a mere rubber stamp, and contracts are just mere formalities. Hard work and merit are often overlooked, while connections and chronism reign supreme. This toxic cycle demoralizes talents, drives capable individuals to seek greener pastures, and undermines the very fabric of public administration. I believe it's a time, and it's the right time, for a paradigm shift. A performance-driven culture that rewards merit, punishes incompetence, and fosters a sense of accountability. By doing so, Ghana, your Ghana, my Ghana, our Ghana, can attract and retain top talent, restore dignity to public service, and deliver value to its citizens. But we cannot talk about performance without confronting the legal and structural environment that shapes the system. Ghana's constitutional architecture gives the executive far too much power in appointments. Virtually every head of a public corporation owes their position to political goodwill, not professional track record. In other words, their allegiance is to a political goodwill. The outcome is predictable then. When loyalty becomes more valuable than competence, then square pegs suddenly find themselves in round holes, expected to run institutions they barely understand. The fear of losing one's job should come from failing to deliver, not from failing to show political allegiance. Holding placards and shouting party slogans should not be the reason for appointment. Yet today, career public servants can be tossed out like a relegated, threatened club's manager. Not because they failed to perform, but simply because a new government is in power and wants its own people to be in the helm of affairs. If the Constitution is to serve the public interest, it definitely must create a buffer that protects professionalism. We are running with a Constitution that was put together at a time when we were moving from a military regime. So it only makes logical sense that some considerations in there were supposed to protect interests. But after this many years, reform is overdue. The executive should not be appointing heads of every public corporation. We should begin to have a board-driven competitive recruitment. That should be the norm we should be looking at. Tenure should be secured and tied to employment contract, and to measurable KPIs, and to productivity. Dismissal should follow a fair, transparent, and just process based on performance and not on political allegiance. Ghana has a very brilliant, capable people. What we lack is a governance model that treats public service with the same seriousness that a football club treats its technical bench. When the right people are hired, expectations are clear, and accountability is real. Institutions thrive when incompetence is protected and performance is optional. When this happens, it's the nation that pays the price. A results-based public administration may sound tough, I agree, but it would be good for Ghana. After all, if we demand excellence from our football clubs, Why should we settle for anything less from the people trusted to run our country? Why? I want to show appreciation to Nana Boampong Esquire for his input, tremendous input into the reflections this morning. We'll be right back after this break.
For decades, we have helped businesses connect with their trade partners all over the globe. From Ghana to Burkina Faso, Côte d'Ivoire, Benin, Togo, Senegal, China, Morocco, France, Netherlands, and many other countries. We have made it possible to bring Ghana to the world. We have brought small and medium businesses closer to their customers across the regions in Ghana with our SME support facilities. We have brought relief and smiles to the faces of families with our employee personal loans. With our cutting-edge technology and digital support, we take the burden of complex thinking off you, making life simple. That is who we are, as close as a partner. Bank of Africa. We are indeed the African bank with the global reach.
Well, welcome back from our break, and thank you for staying tuned to the program. This morning we promised to have a very fulfilling and engaged discussion. Just all the angles for you to appreciate whatever is going on the front. We'll start with the OSP discussions, but before I do that, I would introduce my panel in studio. I have right seated next to me James Kofi Afedo. He's a private legal practitioner and a member of the NDC legal team. Good morning, James.
Good morning, KOJO.
I hope you're doing well.
Very, very well.
Right. I like your small beard. It's almost like mine.
No, this one is baby beard. Yours is the bigger one. Yeah.
Right. Well, next to James, I have Austin KWABENA BRAKO-POWERS. He's also a private legal practitioner. Austin, good morning.
Good morning, KOJO.
And thank you for a repeat. You've done a back-to-back.
Yeah, we'll do it.
Right. Right. And today I have in studio, I've pulled away from Zoom, Dr. Jalil. Doc, good morning.
Good morning.
Today I've brought you early. I've got you to wake up early.
Yeah, it's
good. Okay. We'll also be joined later on Zoom by MUSSA DANKWAH. So as it comes in, we would engage him along the way. So we start with the OSP. The underlining question is to go or not to go, or SP, to go or not to go. I'm drawing the distinction between the SP and the OSP because one is the office and one is the personality occupying the office. So what exactly or who exactly are we asking to go? So I'll start with James, considering that his party in Parliament were the ones who sponsored a private members bill, which later was withdrawn. But I would start with him. James, what was the rationale, what was the reasoning behind the bill in the first place, even though it's been withdrawn? But what was the reasoning behind the bill in the first place?
Well, I would like to first state that the bill was actually, I believe, as far as I understand, work in progress. And unfortunately leaked into the public domain earlier than the proponents had in mind. That's why it really joined the fray. But the real issue is that this is an institution that has been created as, if not a solution, one of the solutions to the systemic problem of corruption, which we have had over the years. The thinking was right. The conceptualization was right.
When you say the thinking, you mean the thinking of the creation of the office?
Of the creation of the office, yes, was right. The conceptualization of the office itself was right. The legal framework setting up the office was also right, but with some limitations. Unfortunately, the operationalization of the office has actually suffered a bit of inefficiency, lack of resources, a bit of political frustration and all of that, which resulted in the former OSP resigning and leaving. And then the new one came in, again, the same issues existed. So actually making the office become fully functional and effective took a lot of time. However, the people who have been very angry and upset about the deep-seated corruption and the stealing of public resources are in a hurry to see results. So if after nearly 8 years, 7, 8 years, something that was supposed to deliver result is not delivering the result that the people want, obviously that could lead to frustration. And that is why we are here. So if you look back, you want to look at all the things that happened under the former regime whilst they were in office. And then find out which of those has been successfully, dealt with by the OSP. And it's very hard to say. Yes, they've had some successes in, uncovering ghost names and prosecuting some of the people and asking them to pay back some of the money. But that is not the most important interest of the people. We're talking about billions of dollars, of stolen money. So if the results are not coming, the people have a right to be frustrated. And so out of that frustration, people feel that the office is not needed, or that the people in the office are not performing. I mean, some of them have described the current OSP as incompetent and all of those things. But I know the current OSP. He's a very, very good lawyer. I mean, criminal lawyer. He knows his stuff. He's someone that you cannot easily push over, So when the results are not coming, then the people say that, okay, then we don't need this. So it should go. That is what all of this thing has been. And right from the beginning, some people on my side actually even believed that the creation of the office was not needed because the Attorney General's office is there. He's the one constitutionally mandated to initiate and prosecute. So if the Attorney General is there, why are you ceding some of the Attorney General's powers to another institution? That is more or less like duplication. So they have a right to still hold on to that view, right? If they believe that the creation of the office itself is wrong, they have a right to do that. What happened in terms of this bill that was under consideration, when I say consideration, not in the House of Parliament, I mean between the proponents of the bill, was an attempt to actually justify the frustration that this office is not needed, or that the evidence that exists is that it is not delivering on the results. Therefore, it must go. People disagree with that, and including His Excellency the President himself, who disagrees with that. That is why he actually pleaded with his majority leader and the chief whip to consider withdrawing or stopping that process. And there's a reason why. This is a president who actually campaigned vigorously on an anti-corruption platform and said that when he comes to power, he's going to prosecute the program called ORA to recover all the monies that have been stolen. It is counterproductive and inconsistent for the same person to be seen as the one saying the most important institution that has been created to fight corruption or to deal with the corruption problem, it should go away. It doesn't tally. So that is why, I mean, he's a very wise person. You know, he will listen to everybody and then come to the decision that he thinks is in the interest of the state. That is why he said that, no, it's not going. What we need is reform. Clearly, there is a limitation. For me, one of the things that I see is a limitation, and I think a lot of people have talked about it, is the fact that the OSP is supposed to be an independent office, has wide, powers to investigate, to arrest, to search, to seize, assets that he considered, or the office considers, to be proceeds of corruption. So my point is, if the institution is given such wide powers, why should they now seek the Attorney General's permission before they prosecute? After they've done all of these things, it's supposed to be an independent institution.
Right.
Why should they still be answerable or, go to the Attorney General to get powers before it can go to court against these people that he has found evidence of corruption? That is the limitation. And that obviously requires reform. It does not justify the total scrapping of the institution, because if we do it, it will be a big disaster for the fight against corruption. You get it?
Yeah.
So I think the consensus now around government is that the institution will stay. But in terms of the OSP himself, there are issues. There are issues. Is he addressing the issues well? I don't know. But in my view, I believe that the talking is too much. I believe it is important that the institution, stays quiet, focus on the job, and not react to everything that is even on social media. You get it? That is what is creating the problem. So is the call justified? To some extent, yes. Is it necessary? In my view, no. And in the view of His Excellency the President, this is not the right time to actually scrap it. Others also said that this institution is actually basically now fully functional and effective about a year or two ago. That's not enough time for such an institution to deliver results. And as a lawyer, I mean, it takes a lot of time to gather evidence, particularly in white-collar crimes like corruption. Because people are stealing, they're covering their backs. So you need a lot of time to investigate, to build sufficient docket before you go to court. 1 year is not enough. 2 years is not enough. So to that extent, I think that the office should stay, the OSP can stay.
The SP.
Sorry, the SP, can stay if he is willing to actually revise his strategies and work better as other independent institutions are supposed to work.
Okay. I'll come back to you on when you say revise strategies, what exactly you mean. But we'll have a quick listen and watch of the majority leader in Parliament when he was speaking to the bill. Then right after, we would also listen to the President give his opinion on what he considers to be premature. Let's take a watch and a listen.
I believe that it is high time that this Parliament reconsiders its decision to approve the establishment of the Office of Special Prosecutor. I think that we should abolish it. We haven't reported a single scandal. And we haven't reported a single scandal because of the political commitment to ensure accountability. And we are available. It's not about creating fanciful institutions and giving them fanciful names. We have seen it. The money that we are giving to the Office of Special Prosecutor, let's resource the Attorney General's office. And I'm sure that this particular Attorney General will produce the kind of results that we expect of him. When there's a corruption case and one runs and then places its hands on it, then the other is clearly, disabled from dealing with it. Even if the one that has rushed first to take it is obviously not politically committed to fighting it. So there's clear confusion. I think that we should use this opportunity to streamline it. Let one person lead the fight against corruption as stipulated by this constitution. If you believe the office of special prosecutor is not fit for purpose, you have the majority, you call us micro-minority, we are mighty minority indeed. Repeal it. When the law is applied unfairly against a citizen, it doesn't matter whether he's from the north or the south. Mr. Speaker, it doesn't matter whether he's an NDC member or an MPP member. Let us insist, that is our only safeguard, that if the Honorable Mahama Yerga is suspected to have committed an offense, he should be taken through proper due process. His rights should be respected. If it is Abu-Jinapo, I should be taken through due process. My rights should be respected. Mr. Speaker, that is the only way we can build a civilized, prosperous nation. That's the only way.
If we all agree that it is serving no purpose, we know what to do as a house. And so we do that.
The people of Ghana will not forgive us if people develop impunity in terms of abusing the trust that people have put in them. And so that's why we're resourcing the Economic and Organized Crime Office and the other anti-corruption institutions, including the Office of the Special Prosecutor. And recently, there have been some controversy with the Office of the Special Prosecutor. I think it's premature to call for the closure of that office. The unique thing about that office is it is the only anti-corruption agency that has prosecutorial powers to be able to prosecute themselves without going through the Attorney General. And so people had mistrust with the Attorney General because the Attorney General normally is a member of government and is a minister of state. And so they believe that the Attorney General will be very reluctant to prosecute his own. But if there's an independent office like the Office of the Special Prosecutor, it won't matter who you are because they have security of tenure and they have prosecutorial powers, whether you're a member of government or you're a member of a previous government or you are anybody who has, misappropriated public funds. They have the...
So as the president said, the creation of the office was or is supposed to come with some level of independence and authority for them to pursue and prosecute corruption and corruption-related offenses. Doc, I'll be coming to you, but before I do, I would want to pay attention to the the 2025 half-year report published by the Office of the OSP. There were 8 cases that has caught my attention. If you have a copy of the report, you can check page 27. There is the Republic versus Mustafa Abdul Hamid and 9 others, which is a case that is ongoing. There is the Republic versus Issa Seidu and 3 others. There is the Republic versus Charles Cromwell, Nana Benin, Unuawontu Bisu and 2 others. There is the Republic versus Ibrahim Kofi Sesa and another. There is the Republic versus Tahidu Yakubu and 5 others. There is the Republic versus Alexander KWABENA Safo Kantanka, which is currently on appeal. There is the Republic versus Sumaila Abdul Rahman and 3 others. There's the Republic versus Ajenim Boateng Eje. The Republic versus, yes, so these are 8 prosecutions currently ongoing. Some started as far back as 2023 and is still ongoing. So, Doc, clearly, is it the case that Ghanaians are not reading? Because if you pick the half-year report, it gives the impression that the OSP and by extension the SP is not as dormant or sleeping as we are making it seem. But actually, if you go through the report, and it's a 50-page report, you can actually see real work being done. So is it a case that we are not reading and we are just rushing to ask for the office to be scrapped?
Thank you very much, KOJO, and good morning to the viewers. What I would say is that I wouldn't say that maybe Ghanaians, people do not read, okay? I think that it's because people have that belief that we are virtually being consumed by corruption. Okay, so looking at the perception of corruption in the country, right? And especially just, voting out a government where people believed that the government was very corrupt, okay? So there were people are expecting that they will see more prosecutions than what they are seeing. Okay, so I think that is what is framing, the thinking of people that maybe the OSP is not doing enough. I think this is about the 4th time we are discussing the OSP on this program, okay? And from the very first day, I said that I didn't support the idea of scrapping the OSP, especially looking at the circumstances surrounding, the need for the creation of the Office of Special Prosecutor, right? So, so basically that was my position, and I'm happy that at the time, and especially the discussions, that the debate in Parliament, I thought that maybe within few weeks we're going to see the office scrap. But I was happy that people started talking about the fact that it's important. The Office of Special Prosecutor's office is Office of Special Prosecutor is a very critical institution in the fight against corruption, right? So if you look at the demands at the time, and I think over here we talk about even the United Nations Convention Against Corruption, where they also made recommendation for state parties to create or to establish independent special prosecutors to be responsible for corruption. All right. So I think that I'm happy that the president himself has also added his voice, because he's a person who said that it was corruption was one of the key issues, and then to see that OSP will be scrapped under him just under 1 year would have been something else, right? So, and if you look at the debate in Parliament, it's like the two parties agree that the OSP, the office must go, right? They agree that the office must go. So if you look at it, and over here, I said that if you look at, even though there was the demand for the creation of the office, there were issues, especially with the MPP, and then the rationale of creating it at the time, and even appointing Martin Amidu to be the prosecutor and all that. So from the beginning, from the onset, they were not happy about it. And for the NDC at the time, they also saw the OSP, even the appointment of Martin Amidu is like to come and deal with the NDC. So around the time, that was the politics, right? So the NDC from the beginning were not happy about it, apart from the fact that they discussed, the issues about the Article 88, because they said that the Article 88 is only the Attorney General who should be responsible for prosecution. So why are you bringing in and that kind of thing? But I think if you look at the Act, I think that they walked a tightrope, right? Even though, my colleague talked about the fact that reform, where they talk about the independence, okay, where it should now, maybe they need to look at that. I think that it was because of the article, the 88, that's why they tried to to ensure that maybe they will not sidestep that. Some people felt that, it will be in contravention of 88. But the fact is that there are other institutions who are also performing, similar function. The police performs some function, UOKWE and others. So I think that the OSP is also doing something. Only that it has been empowered specifically to be responsible for corruption and corruption-related cases. So maybe moving forward, like he said, I think that if that, Article 88 is amended, especially the Constitution Review Committee, so that OSP will be very independent, responsible for, corruption-related cases. I think that it will do. And if you look at the debate in Parliament that day, especially from the majority leader, Honorable Mahama Ayarga, he made a point, in justifying why the office must go. And then he said that, corruption is the fight against corruption is a function of political leadership. And because if you look at over the period of 10 months, 11 months, okay, so far NDC, they have not recorded any, corruption. It's because of the commitment of President John Dramani Mahama against corruption, all right? It's commendable. But the point is that he didn't also think about the fact that what about moving forward, whether we are going to have another president who will be that committed, okay? So in making laws, we should not just limit it to, or maybe when we are taking decisions, it should not just be fixated up or centered on the fact that maybe because this person has been able to do it, we should also think about the fact that someone will not be committed to it, all right? So I think that is where we are, and I'm happy that now people are saying that, and they have also withdrawn. I mean, the bill, was it even put?
No, I think it wasn't.
I think it wasn't, right? It was just in this that they were going to do that. So I think that the OSP is very important, okay? Because if you look at the powers, I think that what they can do, if you look at the Attorney General and others, because like maybe for the lawyers normally talk about the fact that maybe in criminal prosecution, the burden of proof should be beyond reasonable doubt and all that. But if you look at the Act, there are some provisions that are very, very critical, which is very good for the OSP. Okay, it's what we call the reverse onus or reverse burden provisions. Okay, so they empower, the OSP. So if you look at the Act, you see tools like the disclosures, seizures, right, and other things, confiscation. So all these things are very, very important for that office to be able to execute, the mandate that they have been listening. So basically, I think that, so in principle, looking at the fact, I think that OSP has come to stay, and we must do everything necessary to ensure that we empower them. Where there are problems, at least we have had it over the period of 7 years, right? Okay, so we have 2, prosecuted. The second one, I think is almost about 5 years or so. So it means that he has only 2 years. Because he has only 1 term.
Yes.
1 term, 7 years. That's all. Non-renewable 7 years. I think it is the deputies that are 5 years and then another 5 years, right? So 5 years, we should just look at the period. Okay, by the time he's leaving office, so that we can take a very good, account of what has happened over the period and see what are some of the things. And I believe that maybe the Constitutional Review Committee, even though I know they will be submitting their report, I hope that they would have, look at some of these things to see how social prosecutor can function effectively, can be made truly independent, in the Constitution moving forward, so that we'll be able to empower and be able to do that. But talking about the individuals, okay, the SPs, right? If there, someone commit, if there are evidences that maybe a particular person, SP, has committed any offense or something, I think that it is within the right of people to kickstart the processes like others have done, writing petitions, okay? So that we'll see if there is something. If there is no wrongdoing, the man should continue to do his work. So the most important thing is that we are all committed to getting, corruption fought, and we believe that the OSP should be capable and is capable of doing that. So we should rather give the OSP whatever it takes for it to be able to fight corruption effectively.
Thank you. Thank you. Viewers, we've been joined in studio by lawyer ENOCH AFOAKWAH. He's a member of the NPP legal team. Lawyer, good morning.
Good morning, and a very good morning to my co-panelists, especially my brother, whom I've seen for a long time, was in BRAKO-POWERS. He dreamt of having his law firm Powers and Powers Chambers as far back as 2010, when we were having our USA Congress, where they cooked some injunction application in the name of Powers and Powers Chambers. And here he sits.
Nice one. Nice one. Okay, so I'll give you a second to breathe, then I'll come to you. Yeah. Powers, I've heard James speak. James made a very important point that fighting white-collar crime does not take just 6 months, 1 year. Sometimes it can even take 2 years. Recently, a lot of the cases that we have heard of extradition, if they tell you how long the investigation took before they even could come to the conclusion that these people are committing romance, scam, and all those things, it takes years. Is it the case that the people are too hungry for conviction, that we are being too sentimental with the discussion on the OSP, that we are not giving it enough time to actually do its work properly and come with airtight prosecutorial documentation, whatever it is? Is that the case?
Well, I think this is an important question that should have been posed to Mahama Yariga, because he's a lawyer, and also Dafiamepo. These are lawyers. And my thinking is that, and your thinking, that if it does take that while, why the rush? And why even mooting the idea of drafting a private member's bill to repeal the office in the first place? Because these are some of the questions we should be asking them. Then what becomes of ORA, Operation Recover All? Do you remember? It was one of the pillars, major pillars of the NDC campaign team. Their campaign messages, one of their core campaign messages, or message, that they will recover all loot. And in fact, they told Ghanaians that there are some elements, some former party, let me say, appointees who had siphoned or stolen state money or funds. Then we should be asking them, then what becomes of their commitment? In fact, what happened, had it not be the president's intervention, it casts major doubt on the government's anti-corruption fight. These are your own people fighting you. These are questions Ghanaians should be asking. The double standard. Where is your commitment as a government? If you want to eradicate or minimally reduce corruption, where lies your commitment? I think sometimes let's go beyond the mere rhetoric. So we always say the OSP is independent. I have said that, and I'm happy my brother is mooting the idea of going as amicus Korea to, in fact, to join the action that is before the Supreme Court. The action filed by a colleague lawyer, Noah, challenging some provisions of the OSP Act 959. I think, I call him president because he was then the user president. University Student Association.
He won?
Yeah, he won.
When your injunction didn't work?
Oh, it was even to his advantage.
Advantage, yeah.
Yes,
he gave him time to campaign.
Yeah, it was to his advantage. So I think Enoch is in the right. The thing is that, KOJO, when they say the OSP is independent, I think those people, they may not have read they may not really have read Act 959. And particularly Article 88.4 of the 1992 Constitution. If you read the two, particularly when you read Section 4.2 of Act 959, and you read Article 88.4, you come to a better appreciation that the OSP is not independent. And I don't think there's anything wrong with the Act 959, that the previous government did. I don't see anything wrong with it. They have not taken away the powers of the Attorney General and giving it to the OSP. If you read in fact, KOJO, maybe you can even project Section 4.2 of Act 959.
Okay.
It makes it abundantly clear. So when people say the OSP is independent, so by reason of that, we have to repeal it because it amounts to usurping the prosecutorial powers of, and it amounts to unconstitutionality. I don't get them. It means that they have not thoroughly read the Act and read the Constitution. Because when you read the two, you understand, you come to a perfect understanding that the OSP operates under the authority. And even when you read Section 4.2, it makes it clear that the OSP is subject to the Attorney General. Okay, so let me read
yes, the 4.2. The heading is Mandate of the Office.
Yes.
It says that subject to Clause 4 of Article 88, so I'll go to Clause 4 after reading this,
yes,
of the Constitution. The office shall, for the purposes of this Act, be authorized by the Attorney General to initiate and conduct the prosecution of corruption and corruption-related offenses. And the key word here is that the office shall, for the purposes of this Act. Now, let me read what 88.4 says. So, 88.4 says that all offenses prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with any law.
Beautiful. So the combined effect of Section 4.2 and Article 88.4 is to the effect that the OSP is not independent. Simplicity. Because in terms of prosecution, because clearly, if the OSP would get to the advocacy, the dissemination of, or, they train students with regards to, as part of the anti-corruption efforts, they take them through some education. As for those ones, we're talking about prosecution. In fact, that is a major reason why the OSP is in the news today. And, KOJO, the thing is that I have maintained, if the OSP is handling a particular matter and the Attorney General is displeased with the pace, the Attorney General has authority to recall the docket. Is it not abundantly clear from the provisions that you read? It's clear. So this hide and seek, the OSP is independent, and so we need to repeal the Act 95. They should come clear. Tell us, what is your motivation? What is their motivation? I surmise that their motivation may be that the OSP has indicated that irrespective of the political party you belong and wherever you come from, whether from the north or the south, the OSP is ready to come after you. That is where I think they are scared. But, in fact, why even the rush? In fact, Doc was outlining the tenor of the OSP and the deputy. Why the rush? Why is NDC in rush? Because this thing should have even been done by the MPP. Because they are people, past appointees, are before court. The OSP has arraigned them in court. So the MPP should even be crying more than the current government. Because you promised. You rode to power on the back of ORA, Operation Recover All Loot. So why are you even being more Catholic than the Pope? The Pope, the owner of the Catholic Church, you are being more Catholic than the Pope. Why is that? What is the motivation? And I think the president did the right thing, because the president clearly understood, in fact, the tenor of Ghanaians, in fact, the voices of Ghanaians. The president understood the message. Because you could not have promised us that you were coming to minimally or tackle corruption, and your own people are in parliament saying they want to repeal the office of the special prosecutor. And KOJO, I have again maintained that I don't understand this fixation on the OSP, that the OSP is supposed to handle corruption. Is the OSP the only institution that is supposed to handle corruption? Why? Did we create the OSP to come and, in fact, cater to all the corrupt activities in the country? Why do we elevate the OSP to the status of Jesus Christ?
That's what the Act has done.
That's what I'm saying. Corruption. The OSP has specific areas of corruption to handle. Specific areas.
Yes.
Yes. Specific areas. He referred to corruption as one of the endemic things that is robbing Ghanaians of, in fact, decent living. And we all know. In fact, Doc, I'm sure, has done a lot of, has written a lot of papers on the effect of, debilitating effect of corruption. The Attorney General prosecutes when it comes to corruption. In fact, the Attorney General can decide that even in the cases the OSP is handling, he will take over. Didn't you see that from the provisions? Yes. It says initiation and prosecution. So he can tell, the Attorney General can direct the OSP, don't prosecute this matter. Send it to me. Or, okay, I'm handling this matter, take over. These are matters that are clear. Someone will say, it's so plain that you don't need any spectacle to see. Yes. Is it?
Millions of that defies their logic in the case of expertise and network.
Of course. I mean, in those exceptions. But KOJO, the thing is, the NDC must understand that they are not doing the bidding of Ghanaians. What they are doing is to cover themselves. They are protecting themselves in the event they are out of power. There wouldn't be any special prosecutor to be coming after them. Why are you now saying the Attorney General is more capable? How many cases has the Attorney General even won? How many convictions has he secured since he was appointed? How many convictions? And how many cases? Look at the cases the Attorney General has arraigned in court. What is the nature of, what is the progress? Sometimes when we make certain comments, right, it's just laughable. Because a lawyer saying the current Attorney General is ready, is showing the capability to handle the matter. But you were in Parliament when the Act was being passed. And any act passed by Parliament, whether you oppose it or you are not in favor, it becomes binding, an act of Parliament. So, KOJO, this whole shenanigan is much ado about nothing.
Okay. I'll leave you on that note. AFOAKWAH, now, riding on the Constitution, the 88.4, and listening to what the majority leader said, he made one statement that it's become the bane that if the special prosecutor or the OSP picks up a case, nobody else can come for that case. So now, if the case takes forever, it stays with him. From what Powers has just said and from what the Constitution says, it contradicts that. Because it means that the Attorney General can actually even ask that, bring this case back and I'll prosecute it if it's delaying. If that is the case, then what really was the majority leader saying as the reason why, one of the reasons why he thinks that the office should be scrapped?
Yeah, KOJO, let me say a very good morning to our cherished viewers. I say a very good morning to yourself once again. With celestial respect to our friend, the majority leader, I believe there is a personal vendetta against the office of the special prosecutor as a result of what he has gone through in the past. As far as the prosecution of his purchase of some Toyota Land Cruisers with the loans that he took from Parliament is concerned. You remember when the first special prosecutor, Martin Alamisi Benkaiser Amidu, the first special prosecutor decided to prosecute Mr. Ayariga, Honorable Ayariga, on the basis that he took a loan from Parliament for the purpose of procuring a brand new vehicle, for the purpose of serving the people of his constituency. And in furtherance of that, there was some diversion of funds, where he decided to go to Dubai to purchase some used Toyota Land Cruisers, I think 2 or 3 of them. Then it ended up to be a corruption or corruption-related offense because the intended purpose of the loan was not materialized as a result of the purchase, because it is straight, buy brand new vehicles. And you elected to purchase used vehicles. It was quite a bit trivial, to my understanding, because judging from the fact that that's why I'm proposing that the Office of Special Prosecutor should be given a case classification guideline so that the OSP would know the threshold of a matter that can before the OSP, where the OSP will focus on. Because if there's a case classification guideline per its legislative instrument, they will know that, yes, the threshold, if it doesn't meet, say, $100,000 or $200,000, say $1 million, it doesn't go to the Office of Special Prosecutor because it's a specialized agency with all the resources at its disposal to investigate corruption and corruption-related offenses, especially in its grave format. But Mr. Alamisi Benkaiser chose to go after the now majority leader, who I believe is a bit pained because of what he went through, the tainted image, credibility, and the whole lot of things that he went through as a result of this prosecution.
SP took him off. It was the current one that he is
fighting.
Cleared him.
He's not fighting the current one. He's fighting the office. Because if he was fighting the current one, he would have triggered Section 15 of Act 959, which goes to the effect that if you think that the OSP is inefficient in performing his mandate or has misconducted himself in a manner that is unwarranted of the office or whatever that the Act prescribes, you file misbehavior, you file a petition, and the petition must be sent to the president. It seems like the removal of the Chief Justice or the removal of Superior Court Justices under Article 146 of the Constitution. So if he went on that tangent procedurally, it would have been a target against Mr. Kisie Jaben, who at once upon a time cleared him of that trauma. But this is against the office. Why is politicians going after the Office of Special Prosecutor? One, it is the only office that politicians have no control. Simplicity. One, politicians are in control of IOCO. Politicians are in control of all other allied security agencies, including almighty Ghana Police Service, because the IGP was appointed by the president. Once he was appointed by the president, what becomes of him? subject to the faceless controls. And that with the OSP, you see, the office was established not upon coming into office of the president and DANKWAH Akufo-Addo. It was a desire of the people of Ghana to have that office established through teaming advocacy by Ghana Coalition, Ghana Anti-Corruption Coalition, by media, by all and sundry, as a result of how we term it as empowering, weaponizing security agencies against political opponents. So it came to the realization that why don't we get an independent office devoid of partisanship, that the office will be mandated to be able to carry out that mandate. You remember when President Kufuor came to office, the quality grain scandal and the like that were prosecuted, Mr. Kwame Pepra, Dan Abodakwi, and the whole, you can mention the names. Although they had convictions in the courts, convictions were secured by courts properly constituted in accordance with the laws of the Republic of Ghana. Because of extreme partisanship, the judgments, the procedure were colored at manipulations of the judiciary against political opponents. So, the accountability that we got as a result of these prosecutions were tainted with political coloration. And you remember that the trajectory of this country is that when a regime is in power, it protects its own. Now, none of the appointees of His Excellency President John Dramani Mahama has sinned against the laws of the Republic. None. None has sinned. All are saints. But let the table turn. The eggs that they are sitting on can be counted. It is upon this that the OSP was established. And it was established in furtherance with the preamble of our national constitution. Anytime you open the 1992 constitution, the people of Ghana communicate to you. Because the preamble says that we, the people of Ghana, we, the people of Ghana, in the exercise of our natural and inalienable right, it's a communication from the good people of this country. And out of this, born out of it, is where Article 88(2), pursuant to Article 88(2), the prosecutorial powers of the Attorney General was delegated to the Office of Special Prosecutor to prosecute, to investigate and prosecute corruption and corruption-related offenses, pursuant to Section 3 of the Office of Special Prosecutor Act 959, and all that ensues. What lies on unconstitutionality that the proponents of truth, probity, accountability, and justice are postulating? They are now becoming more Catholic than the Pope. Looking at the demeanor and the posturing of Mr. Mahama Yariga, my own learned brother Nelson Eche Kujo Dafiamapo, and the likes on the majority side, Kojo, they are becoming more Catholics than the Pope. And the Pope has spoken. We have a question as to the direction of the Pope, because he is also subjecting the legislative arm to the whims and caprices of the executive. There is a popular candidate that the Ebusu Akumem NPN is war. What has been the discussion of the majority in conclave before they came out with these shenanigans? Do you know why I'm going as an amicus curiae in respect of the matter before the Supreme Court? This is an attempt to dilute the powers of the Office of Special Prosecutor through judicial means. While they are seeking to repeal the act and to collapse the office that has suffered the social accountability actions of the people of this country, they have now sent one of their own to the four corners of the walls of the Supreme Court of Ghana to go. And this is a whole match. And I just wrote on my Facebook that the whole match will be competitive because there's an amicus curiae. The court is a court of record. And no matter what, I believe that justice are sworn in to administer justice. Judges are sworn in to administer justice in accordance with law and due process. judges settle matters in dispute. So if it's a home match and the arguments are cogent, there's no, they are not crossing issues, and the direction of the state and that of the applicant or the plaintiff is coterminous, is similar. Where lies the judges? The judges will pronounce on what is before them. So there is a need for a third party, an amicus, a friend of the court. And I am empowered by section rule 1 of the professional conduct etiquette rules of lawyers, LI 2423, that a lawyer has 3 cardinal duties. You owe a duty to your client, to the public, and to the courts as an officer of the courts. So I am performing 2 dual functions as an amicus humanis generis, a friend of the human race, going in as a friend of the court, an amicus curiae, to present the minds of Ghanaians before the law lords of the Republic of Ghana, to help them.
When you say the Latin, then you break it down.
Yes.
For my viewers, it's too early. They've not drank.
Yeah. So amicus humanis generis is only a friend of the human race, and you are going as a philanthropist. You are not taking any money, any consideration from anybody, but in the interest of humanity.
So generis simply means general.
The human race, yes. So going in as an amicus curiae is a friend of the court.
So the I am going to perform. Here is the court.
Yes.
So the amicus is the friend.
Amicus is the friend. So going in that tangent is in fulfillment of my mandate under Rule 1 of LI 2423, pursuant to the preamble of the National Constitution, that we the people of Ghana, and it says that all powers exercised by government is born out of that of the sovereign people of this country. So government is exercising the power I gave him on December 7th, upon which he was sworn in on 7th December. 7th January, sorry. And that is why I mentioned earlier that whenever you open the Constitution, the preamble is a communication from the good people of this country,
right,
speaking to all well-meaning Ghanaians. KOJO, we should not dare, we should not allow the long arm of politicians to stretch into the ambit of the Office of the Special Prosecutor. That is the only anti-corruption ombudsman left for us. I have my own issues with the person at the helm of affairs, Mr. Kisia Jabe, in respect of some human rights violations and in respect of some ultra-virus conduct of the Office of the Special Prosecutor. Recently, you remember the arrest of one of our own, Mr. Martin Pebu, for obstructing some military officers at the Office of the Special Prosecutor. Why? Is it part of the mandate of the Office of the Special Prosecutor? There's no law that backs the action of the Office of the Special Prosecutor to arrest Mr. Martin Pebu, cautioning him in respect of obstructing the work of the Office of the Special Prosecutor. No. When you read, is it 68, section 68 of Act 959, it tells you where lies it enumerates obstructing officers of the Special Prosecutor from performing their work and that kind of things. You can't read that as a stand-alone.
It says that their work in accordance to that act, their functions.
Exactly. In accordance with, it should be the combined effect of Section 3 of the Office of the Special Prosecutor Act.
Who defines the functions?
Section 28, that is the powers of the police. It is not to the effect that you can, because you have the powers of the police, you can go bonkers, you can go haywire and decide to exercise the powers of the police. You have the power to arrest, restrict, detain, investigate. Those are the powers of the police. Detain and those kind of things. In respect of Section 3, your investigations on corruption and corruption-related offense. So, if Mr. Martin Pebu is not a person of interest that you are investigating with regards to corruption or corruption-related offense, but he has made an allegation to the effect that the Special Prosecutor is corrupt, if the allegation is baseless, the SP is a lawyer and he knows what to do. because he has also a remedy in law as far as restitution in damages, defamation is concerned. This is not a criminal matter. If Mr. Martin Pebu, as a lawyer, has cogent evidence that can seek the removal or the conviction or the punishment of the SP for any alleged misconduct, he knows the procedure under Section 15. He also cannot go to the OSP and decide who sits on his matter, who receives his petition, who receives his evidence, constitute a board, let the board nominate, and those kind of things is alien to Act 959. So as lawyers, we must duly respect the decision of the Supreme Court in the case of Boyfio versus NTAC Properties Limited, where the Supreme Court clearly stated that when an enactment prescribes a procedure in which an action or something ought to be done, it is only through that procedure. And the OSP Act has prescribed a procedure that remedies this kind of allegations and that thing.
Okay.
File a petition, send to the president. Let the president forward same to the Chief Justice. Let the Chief Justice establish a prima facie case. Within 30 days, the Chief Justice has the mandate to establish a committee to be chaired by a justice of the Supreme Court and a lawyer of not less than 15 years of good standing, and other specialized members should be on board. Once the committee is established, they also have 90-day window, 3 months, to submit their recommendation to His Excellency the President.
Okay.
This is the procedure. So
I'll come back to you.
Enough of the talk shop with no action being done, enough of the tainting, enough of the politicking, enough of let's protect one of our own, enough of let's protect ourselves. Ghanaians should say enough is enough.
Enough is enough. I've noticed
let's
that
protect this beautiful country.
James has made a lot of points. So James, I'll come to you. Before I come to you, because I want to give you a bit of time to speak to us. But briefly, Doc, this issue of separation of powers. In the previous government, there was an instance where parliamentarians presented a petition to the president asking for the finance minister at the time to be, for want of a better term, sacked. Ghanaians spoke against, even though some liked the idea, but some spoke against it, that for the parliamentary or the legislature to move into executive, to tell the executive what to do, is not right. We had an instance also where the judiciary passed a certain judgment when it had to come to, I think it had to do with the sitting in parliament, where the Speaker of Parliament then also gave that there was separation of powers between the judiciary and the legislature. This issue of the legislature wanting to put a private bill and the executive coming with an official letter on the letterhead of the president, advising them to not do, and indeed, they are acknowledging in the House and saying that we will not do. Does this not gradually give the impression that the line separating is actually fainter than we thought it is?
Yeah, I think that is it. The line, especially if we want to talk about separation of powers, okay, it goes with checks and balances. And this operates very well in countries that operate very strict presidential, okay, where you have separation of powers working like in the United States, okay? So where maybe if you are a member of parliament and you want to join the executive, you resign and go, right, in that circle. But if we look at our institutional arrangement, okay, where the president is required to appoint majority of ministers from among members of parliament, so it dilutes that strict separation in a way, okay? Because so if you look at all of them in parliament, and I tell the same thing, I spoke about this issue when the 88 people, petitioned Nana Akufo-Addo for him to remove Ken Oforiatta, right? I said the same thing in the sense that if you look at it, okay, in parliament, every person there working, those of this, every person want to catch the eye of the president, because it is the president who appoints who becomes a minister and what have you. Okay, so even if you are currently occupying a ministerial position, there could be a period where you can be reshuffled, right? So anything that they do, so that is the challenge that we have in countries that operate strict separation of powers. It's very difficult to find something like this. But in our system, some people call it hybrid. I call it new presidential system, because it is only this, especially this provision that says that president must appoint I think it's 58 or 78, one of them, among members of parliament, and this same article 88, right? Other than that, everything that we find in our constitution akin to the presidential system, okay? So basically, that is the whole thing. So once you have the president, okay, and then his executive, okay, or maybe the ministers or members of parliament in that, so there is that cordiality, okay? So, and they do not want to say, if the president says that, okay, in my view, this is it, I think that you should withdraw the case. So just in a strict presidential system, they will not mind the president, they will go ahead and then do it, okay? But here it has implications, okay? So it's like your own party, I mean, you have majority, the president appoints majority of you from among members of parliament to be ministers and all that, and yet you are doing something. Other than that, it's also a signal to parliament that if they had even progressed with it, all right, throughout this, eventually it will come to the desk of the president, and the president, they decide not to assent to it, okay? And then you have to assign reason, even though I think 108 says or thereabout, you can, I mean, parliament can still marshal two-thirds majority to be able to rule, the decision of the president and all that. But looking at, the politics we run and the type of arrangement that we have, always you find a good working relation between parliament and then the president. And that is what the framers of the constitution, in my view, anticipated that maybe at this particular moment, that is what we should do. And that's the same thing happened in, the 88 or over 80 people who petitioned for the removal of this, because Nana Akufo-Addo called them and said that, no, okay, yes, your concerns have been taken, but I think that, and then subsequently, almost about 6 months into the election, that was when Kweno Fureta was removed. So I think that it has to do with the constitution, okay, which ties the executive and then the parliament. So we do not have a very strict situation where the parliament can stand on its authority to do whatever they want to do. So once a party has majority in parliament, that is why the president is also very sure that whatever decisions, whatever policies or whatever they want, if we go to parliament, it means that they will have their members there to approve them to be able to do whatever they want to do. So I think that is where the challenge is.
Okay. Quick one. I have a quick question for you, actually. James, I want to give you a bit more time because I know he wants to respond to you and respond to Enoch.
So I want to touch on what Doc said.
Okay, briefly, let me give you a question to one of my viewers wants me to ask you a question.
So KOJO, here is the thing. With separation of powers, and I think this issue came up when the president sent the message to his people to withdraw the private members bill. I think sometimes we misunderstand the concepts and its application in our society, because some of these Western concepts, we've domesticated them, and sometimes we have statutory and constitutional reforms. We've modified them. So with separation of powers, there are two. We have total separation of powers. Total, and Doc was saying strict. So total, it means that, and when we talk about separation of power, we're talking about separate function, separate institution, and separate personnel. These three factors are very key. In Ghana, we have partial separation of powers. That's why Doc talked about the intermarriage, sometimes between the executive and the legislature. And this is what the framers of the Constitution have in mind. And so sometimes we act or we speak without really understanding the circumstances. Because if you understand the nature and the operation of separation of powers in our society, you understand why the president will send a directive. Because when Parliament makes a law, it is the president or the executive that implements the law. When the OSP Act was passed, didn't Parliament allocate resources for setting up the office? So now if you want to repeal the office, don't you think the president must be consulted? And the president says, hold on, it is too premature to repeal the office. So I think the president did nothing wrong by calling his men to withdraw the private members bill. It was the best solution, because after having spent so much, you just want to wake up one dawn and say the OSP is gone.
No, even that one, is it not funny that in mooting an idea for a private members bill, it should not be such that it will put financial burden on the public purse. So if it will put financial burden on the public purse, you consult the executive first, because it is the executive that plans the affairs of our finances. So
you're going back to the point that you don't think the executive was not aware of what they were doing.
Exactly. No, but even this one, they said...
I have a specific question for you, James.
Even this one, quick one, this one, they said...
Sorry, not James.
No, because James is in a hurry to speak, so...
Yes.
No, so with the...
I'll give him 10 minutes to speak.
Kojo, with the private members bill, I've heard some members of some people connected to the two key personnel say that it won't come with any financial burden, and that's how come they didn't involve the executive. But I think the best decision was taken by the president.
Okay, so James,
Austin.
Austin. Let me call you Powers.
Maybe James wants to go, so
yes, James, I'll give him a flow now. Okay. One of my viewers wants me to ask you that you made mention in your submission that it seems the NDC is being more Catholic than the Pope, and ENOCH repeated the same phrase.
Yeah.
But then they are asking that Professor Michael Kwei has recently openly declared his wish that upon hindsight, he thinks the OSP should not have been established. He was the one who was speaker when this bill came before.
Yes.
So you see also now crying, in this time, you see now crying more than the bereaved. His is not the Pope.
No, I think, so the thing is that they must understand, in fact, the motivation behind Professor Michael Kwei's comment. In fact, his comment, I monitored it, it came out after Martin Kpebu was detained. That was when, I mean, at the night when Martin Kpebu was detained, where he was interviewed, and he said, looking at certain things, he believes, he believes the OSP Act should have been repealed or shouldn't have even seen the light of day. But in fact, contextually, I had issues with even his comment at that material moment, because his comment came at a time when we didn't even have the full complement of fact, particularly surrounding what Martin Kpebu did at the office, at the Special Prosecutor's office, and the resulting reaction of the Special Prosecutor, let me say, the office. Here's the thing. He may have changed his opinion.
Just 2 minutes for me.
No, he may have changed his opinion. That is his own belief.
But Ayariga also changed his opinion, and you were saying that he shouldn't.
The thing is that. Let me support Austin here.
If you are taking from me, I'll come back to you.
Professor Michael Kwei was not a member of parliament.
Austin, if he agrees,
that cannot hold.
If he agrees for you to take it, Enoch, I'll come to you at the end for you to
he was a member of parliament. Here's the thing.
He's a member of parliament.
So the thing is that Michael Kwei's new change does not materially affect even the present conversation. The present conversation is that that's why KOJO initially said that it should have come from the MPP. The MPP, because they have people who are currently facing trials. They should rather be mooting the idea. They should even be moving heaven and hell to get the OSP Act repealed. But a government that promised to recover all loot, and even said that they are convicted, that they know people in the previous administration took monies and diverted funds. You shouldn't be talking about the repeal.
Right. James, so I give you, I'm giving you, gentlemen, James, I'm giving you 10 straight minutes
to
respond, and then I'll come to you.
James coming so that he can add it to his submission. I mentioned that he had a different opinion as to it. That Professor Michael Kwei was a speaker, but was not a member of parliament. In terms of debate, the speaker is not part of the debate. He directs the affairs of parliament.
He's not a member of parliament.
He's not a member of parliament. Right. So once he's not a member of parliament, it was a parliamentary decision that he presided over it. He may have his reservation, but because he's the speaker, he can't contribute to the debate on the floor of parliament. Not at all. Why do you blame him? So probably now that he's sharing his views, his private views, as a result of that act. It was an act sponsored by the president.
I think your point is well made.
Government business.
James.
And certainly he cannot be. He has no role. Absolutely.
So James, it's 8:43 now.
Yes.
So at 8:53 exactly, I'll stop you. So let's go.
No problem. I would like to start from that point. Who is Professor Michael Kwei? We all know who he is. We know his background. We know he's a founding member of the New Patriotic Party. He has been an ambassador for the party. He has been a member of parliament for the government, the party in government. He has been a member of parliament for the party before becoming a Speaker of Parliament. In fact, it is not possible for this act to be passed without the majority leader at the time, who is an MPP person, consulting that speaker on these issues. So you can't come today and tell me that when the same person who presided over the passing of the law comes after he's been out of office for 4 or 5 years, comes and says that that office is needless, and then you think that he was a speaker, so it doesn't matter. But then when some other person is saying that, no, this office is needless, let's repeal it, then that person is being hypocritical or is crying more than the bereaved. It can't be like that. And you see, the problem we have in this country is the lack of principles by politicians. That is the problem we have. Because, no, there's no confusion about that.
Don't let him distract you.
There is absolutely...
Don't let anybody distract you.
Yeah, and please.
Enoch.
I was very quiet.
No,
when
he was quiet
everybody
when you were
was
so Enoch.
So when principles come in, you should add that to the lead. Ora.
No, I'm making my point.
James, focus.
What I'm saying is that the problem we have is lack of principles. Something that is right today.
If you look at him, he will interrupt you. So don't look at him. Look at me and your
I have to
viewers.
look at him.
Then he will interrupt you.
Something that is right today will be wrong tomorrow because of change of political positions. And that's, with the greatest respect, is the source of chaos, tension that we see in other countries. Ecowas is just saying that in the sub-region there is insecurity and giving a warning about that. A major factor to that is the behavior of politicians. Look at what the respected minority leader is doing in parliament. And you look at the history and you realize that, but this was deputy majority leader just a few months ago. So what has changed? Things that are really clear, supported by law, principle, history, you take a different position and be more or less becoming like an agent provocateur, saying things that are totally necessary just to charge the party people out there to think that something wrong is being done. That creates confusion, that creates tension, that creates, problems. And we need to be very careful of that as a country. Let me come back to the majority leader, Honorable Ayariga. Where, in the last several years, in relation to this particular issue, has he taken a different position? Even the issue about him taking a loan to buy vehicles, Martin Amidu took him on. What was wrong about that? I took a loan that I would pay with my own money with interest. If I decide to use the loan for something else, what is wrong with that? It's my money. I borrowed it. I'm paying back. Where is the corruption in that? But even that is beside the point. This law was passed before Ayariga was taken on by Martin Amidu. And in that parliament, Ayariga was against the law. He said that the Attorney General can do the job. So if today he's still saying the Attorney General can do the job, where is the double standard? I don't see it. The only double standard we are seeing here is that the MPP side, who promoted this law, they believe that the person should stay, but when they are taking their clients on, like senior here, they're against the institution. They're against the special prosecutor. That is the problem. So my point is simple. It is very, very unfair to Honorable Ayariga and Honorable Nelson Dapamopo to say that they are being hypocritical, they are
being more Catholic than the Pope.
More Catholic than the Pope and all of that. It is not right. This has always been their position. And in any case, members of parliament have a right to promote private members' bill. They don't need to consult anybody. They don't need to. And again, let's put this in context. As I said earlier, this was an idea in information. This has not been brought into the House of Parliament. Someone decided to leak it out. So are we saying that people cannot have their intentions and opinions as to what they want to do? Is that a crime? No. Not at all. So when the leader of the party, that is the president,
Focus on me, James.
When the leader of the party.
He said it is okay to mute and agree.
Please.
James, focus on me.
Please.
Powers, James, focus. Let's go.
When the leader of the party, who campaigned on the back of corruption, as I stated earlier, comes out and says, no, this office must stay. What we need is reform. That is leadership. That is leadership. That is principles. That is someone who is saying that, listen, I came to office to fight corruption. The people of Ghana support me. MUSSA DANKWAH's research has shown consistently that this government, everybody in this country thinks that is headed in the right direction. Everybody. On all factors, except MPP. No, you're not.
So what it means that 41% don't agree that it's
38% don't agree that
I thought it was 41.
No, that's it.
Lack of principle.
Okay, let's move on. James, let's go.
Lack of principle.
That, we're just being political. Now let's come back.
Politics doesn't mean you should lie. Because the media has the four faces of the realm is to inform, to educate, and to entertain. And now to make money because you are playing adverts. Are you getting it? So your core function of education doesn't mean that.
James, let's come back. Before he starts running our financials online.
It should be mooted differently as it is because of politics.
Okay. Noted.
So what I'm saying
no
is...
wonder the struggle to pass the Anti-LGBT Act has now subsided. There is in a
James, let's focus. AFOAKWAH would throw us out of gear if we allow him.
Oh, no, me? I'll continue on where I want to go to. You see, so please, let's just be fair. When we are here, we are addressing the people of Ghana who, as history has shown, are very discerning. They can be quiet for many years, but they know what they are doing. And when it gets to the polls, they know what to do. Let's be fair to them. Let's be fair to principles. Ayariga and Premature have not done anything wrong. They are members of parliament in their own right. They have a right to promote any bill they want to promote, just like anybody in parliament. Why is it that today NPP are the biggest supporters of the anti-LGBT bill in parliament? Why? A few months ago, these are people who didn't want that bill to be passed. You get it? So the point is that there is absolutely...
Please allow me to... Gentlemen.
Those who wanted the bill to pass.
I remember the bill... The sponsors of the bill was in Team Fojo.
Yes, we're in Team Fojo.
Was and is an MPP.
Yep.
So, again, if you say that the MPP did not want it to be passed, because in Parliament, the bill was...
Granted Agwendo. That we didn't want it to be passed. Those who wanted the bill to be passed, what is their current position?
Let's put issues into context. With this particular one, it was sent to the president for him to assent. And the president refused.
It was not sent to the president.
No.
It was not.
Gentlemen.
He did not tell them.
He asked them not to bring it.
Our discussion this morning is on OSP.
It was never sent to the president.
When we have a discussion on the LGBT, but we are on OSP.
Because of the principle that we are roping all these things
in. Yeah, you rope a lot of things in. You end up roping whether men.
So we will bring all those principles to bear.
It's okay.
For the people of Ghana to make a determination.
Just one more minute to...
MUSSA DANKWAH's research says that MPP's numbers are still going down.
You mentioned something which I like it, that Ghanaians are silent.
James.
And they watch you.
All right, let's go.
One more.
They watch you blow your horn.
Yeah, no problem.
James, one more minute, let's go.
1 more minute?
Yes. If you can check, it's 8:52.
They've taken 5
You allowed them.
No, please.
Let's go.
Please. BRAKO-POWERS says that the NDCs or the government is saying the OSP is too independent and so it should be brought back to anti. Sorry? But you were addressing, majority leader and all of those.
No, you are making a category.
All right. So what I'm saying is that
because in your statement, in your submission, you even said the OSP appears independent. And I said people have...
The OSP was
created... people in general.
The OSP was created...
So don't
listen. The OSP was created to be an independent institution.
It's not true.
It was created for that. Otherwise, we don't need it. So do you support the repeal?
But we've read the provisions.
No. Do you support your interpretation is different from my interpretation.
Yoko, the work that Yoko is doing, can't the police service do that?
So point is, do you support the repeal?
So the work that NIB is doing, can't the police service do that?
Do you support the repeal?
Investigators and NIB are all police officers.
That is the point. The point is this.
So can they also do it?
The point is
when
this.
you are talking about principle, then let's repeal all those institutions and leave the police service to do it.
You see, maybe we should go back to the memorandum to the bill.
When
maybe that will address the point.
The thing is that
we should go back to the memorandum.
You are saying that
there was a problem. The problem was that in the fight against corruption, the institutions that existed were not performing. And they were subject to executive interference. You get it? So people were not being prosecuted for the stealing that they are stealing. For instance, Finance Minister said recently in Parliament that out of this economy, $30 billion was moved out of this country without any evidence supporting it. $30 billion.
This particular declaration made by the president, the finance minister.
Yes.
I have a lot of issues. When we go on the break, I'll discuss it with you because I can't say it on air. Okay, gentlemen.
Now let me just
finish with him so I can take a quick break.
Let me just make up my point. What I'm saying is, the main issue or the main reason why OSP was created was that the fight against corruption was failing. The institutions that existed were not performing. They needed someone independent to be able to deal with current government and past government for all the wrongs they committed. Now, if after a few years of this institution being in existence, only 7 convictions have been obtained, and out of the 7 convictions, none of them involve high-profile corruption, everybody is fair to question that institution.
Is it also fair to assume that then the accusations that were made were probably just some smoke screen? You really did not have any basis, and so that's how come no high caliber prosecutions are ongoing. So can you also mean that?
So his report should report that. He should report that he has concluded an investigation and he didn't find any evidence to support those claims.
But you admit earlier that some of these investigations can take 2 to 3 years.
That is what I'm saying. So I'm saying that.
Didn't the OSP say
there was no case?
He did not say there was no case. He said there was case of money laundering.
Okay, but in the case of the Airbus,
he didn't say there was a case.
Gentlemen, but in the case of the Airbus, the special prosecutor came out to come and say that there was no case.
Yes.
Exactly. So there have been instances where he has investigated and said there's no case.
What I'm saying
is,
one.
He was able to.
Let me learn so I can go on my break. James.
If you continue like this, then we are going to continue like this. So because
no, I won't allow anybody to continue.
I will not allow you to also flow.
James, please pay attention to me. So just I'll give you a final 1 minute so I can take my break.
So I just want to say that what is happening in Parliament, or what was going to happen, was not an issue about personal vendetta. They have a right to still pursue their idea that the creation of this office was usurping the powers of the Attorney General. That is their view. You can't begrudge them for that. The most important point is that the leader of the country says that, no, I came to office on the back of anti-corruption. That is why oral exists. So for that matter, OSP must say. The only thing, as I said earlier, is if the person who is occupying the office has issues, he must change or be removed. And now there's a process to remove him. This is not a process initiated by, government in power. This is not a process initiated by anybody in Parliament representing the NDC. It's a process initiated by individuals who are citizens of this country who think that the guy is failing. So if it goes through and is failed, another OSP will be appointed. Right. The institution must stay.
Right.
Point is, when we are making commentary on these things, let's be fair to the intelligence of the people out there.
Thank you. Viewers, we'll take a quick break. When we come back, we'll be discussing the Kpandai by-elections that is slated for 30th of December. We'll be right back after this break.
For decades, we have helped businesses connect with their trade partners all over the globe. From Ghana to Burkina Faso, Côte d'Ivoire, Benin, Togo, Senegal, China, Morocco, France, Netherlands, and many other countries. We have made it possible to bring Ghana to the world. We have brought small and medium businesses closer to their customers across the regions in Ghana with our SME support facilities. We have brought relief and smiles to the faces of families with our employee personal loans. With our cutting-edge technology and digital support, we take the burden of complex thinking off you, making life simple. That is who we are, as close as a partner. Bank of Africa. We are indeed the African bank with the global reach.
Minority we are concerned, there is no single business that has happened today because the parliamentary proceeding, you have been covering parliamentary proceeding. Have you ever seen that they have taken the maize from its original position while parliamentary business is there? The maize is the symbol of authority to parliament. So when it is out of where it is, that means that there is no authority of parliament. And anything that has happened is illegal. It has never happened. From 1992, they have never passed a motion in parliament where they have taken the maize from its original position. It has never happened that the marshal to parliament, it is guiding the maize whilst motions are being passed. This is an illegality. This is a disgrace to our parliamentary process.
Finally, if you
to advise ourselves, because we know that it is very illegal, it has never happened, it's shameful for our democracy. And even you media men, have you ever one day see that the maize is taken from its original position whilst parliamentary proceedings? What's the essence of the maize? The maize is the symbol of authority to parliament. When the maize is standing still, it means that we are doing our business. It's only at consideration stage that it is tilted to relax the rules. At this stage, the rules was not relaxed, the maize was taken, and it is illegal.
Right, it's sometimes the discussions behind the scene when we go on a break is very interesting. I only wish that the viewers could get to hear some of the discussions behind the scene. Anyway, my panel would want us to go into the OSP again, but they forget that I'm the anchor. So I decide what we should move to. So we are moving to Kpandai. If I have a bit of time, I'll come back to them. They want to do some clarification on the OSP Act, but for now, I'm following my cue. For Kpandai, we've been told by the Electoral Commission that on the 30th of December there would be a rerun of the parliamentary elections. We saw some scenes in court. In Parliament recently, where the minorities staged some, let's call it a stand-up, and then because they believed that once an appeal has been made, it required for it to be heard and a decision taken before even the Clerk of Parliament presents the notice to the Electoral Commission for the Electoral Commission to declare that the elections will be held. And so that discussions are ongoing. However, as those discussions are ongoing, political parties are also on the ground. The NDC has been on ground, according to them, from the very day that the the High Court judgment was made, they started the campaigning. Will the NPP show up? Will the NPP boycott it? Will it leave it as it did with Tamale Central, or this time it would go? It would ask itself not to go, but maybe the MP goes, as was done in Ablekuma recently. What would be the approach? We'll discuss it. But before then, we would want to look at how the figures have looked like for Kpandai over the years. To do that, and after that, we would be joined online or virtually by MUSSA DANKWAH, who would also speak to some works that he has done, some research to give us some information. So let's look at the infographics on how the trajectory has been at Kpandai over the past few years. If we can have that. Okay, so this is in 2008. Kpandai in 2008, when we put all the polling stations together. In 2008, the NDC had majority, 37.24%, total of 10,300 plus votes, and the NPP had 9,800 plus votes, representing 35%. That's in 2008. So in 2008, it was the NDC. In 2012, it was the NPP going to 16,000. So it grew from its 9,000 to 16,000. That's about, let's say, 5,000 or 9 to 16 is 7,000, my gen. Yes, 7,000 plus more votes. And NDC grew by 3,000 votes. Then in 2016, the NPP retained the seat with 19,000, so it grew from 16 to 19,000. That's 3,000 more. The NDC grew from 13 to 15, 13 to 18,000. So at this point, it's been 2-1, 2 for NPP, 1 for NDC. In 2020, the NPP again, the third victory, 25,000. NDC, and NDC had 25,000, NPP 23. So it became 2-2 at this point. NDC grew from its 17 to now 25, and NPP also now moved to 23. So 2 apiece. And then in 2024, which was the fifth one, MPP at the time was announced to have had 27,000, NDC 24,000. So this would have meant that MPP had the third victory and NDC had 2 at the time. However, if you look at what is currently going, you can see that seat, you cannot confidently say that it's a safe seat for any political party. Every other election, it shifts. So either goes blue or it goes green. And so as of today, it's still 2-2, 2 for the blue, 2 for the green. You can see on your screen that the NPP in the 2024 for Kpandai had 53.20, NDC had 46.60, and all the other political parties put together had 0.20. Now, this is what is being contested. Now, to put it in context, what was the issue at stake? That the coalition did not complete and there was some violence at the center. And so all political party representatives were told that the coalition had been put, or the counting had been put on hold. However, the NDC parliamentary candidate says that when it was being recounted, they were not notified. And so for that reason, they believe that fairness fairness was not in play. And for that reason, they are asking for the rerun, which I believe the court has agreed to. And the reason why we are where we are. We have Mr. DANKWAH online. We would speak to him to get his view on what exactly he predicts, and from his analysis and his research and his forecast, how he thinks this will go, considering that now it's 2-2 apiece. Musa, good morning.
Good morning.
How are you doing?
I'm doing very well, thank you.
Yes, once again, your expertise is being called upon. In fact, this year, we have heard of you more in this year than we have ever heard of you in previous years. Tell me, what has been the sentiments so far from where you sit? Why will the MPP not want to go for this rerun? Is it simply because they want to enforce what has happened, or there is the fear that what had happened in the past by-elections this after the 2024 might repeat itself and they will lose another seat?
Right, thank you very much for having me. If you look at the sentiments across the country, and indeed even in Kpandai as I speak to you, it's a different sentiment people are feeling right now. If you look at the approval of the president, it's quite popular in Kpandai, and people are saying that the country is headed in the right direction. Now, if you just suppose that to go into an election to elect a candidate, then you have the pressure of voters either choosing to stick with what was done before, which was later annulled, or look elsewhere and pick a candidate that belongs to the government. It's similar to what we've seen in Akwetia and even in in ABDUL-JALILU. The sentiments, if you are a ruling government or the incumbency, tends to weigh heavily on the elections. But Kpandai is nobody's stronghold. So people could defy the overall sentiment and vote based on what they think, who they think is the best candidate. So far, it is living up to expectation. It is very, very, very close election, according to the polls which will come out on Monday. We expect nothing more than the election being close.
Okay, right. So if we look at the trend analysis that you shared earlier and which is on the screen now, it looks like Kpandai moved from a very strong NDC base in 2000, and gradually from 2008 it started getting a bit saturated into being what you now call nobody's strong hold, because in 2000, if you look at it, that's 54% went to the NDC. Even in 2004, 41%. Even though it was not above the 50, but if you look at it's slim within a space of plus or minus 4%. What would you made the that he could actually even win the seat from 2008 and then 2008 in 2016, and then the last result, which has now been overturned.
Moved from very, very strong NDC to what we call now a swing. And nobody can dispute that. From the presidential election to the parliamentary, the story has been the same. But if you look at it, it is MPP that has been making the grounds in the constituency over the years. And they've come very close to really being able to win the seat. Indeed, I paid the results last time we saw, they won it, but the court has nullified it. Now, what we can say is that this trend suggests that Kpandai people look at the candidates and not the political parties. So the fact that they are NDC or MPP doesn't play a lot into this. They tend to look at the candidates and see who is best to represent them.
Okay. Now, on this particular rerun, what's I don't know whether you've done any works into it so far, whether you've done any research, but what does it look like? Does it look like MPP might get it again, or because of the general feeling that the current government is moving in the right direction, judging from your last work that was done, it might take the turn of Akwetia which we all knew to be that for MPP based on the last election?
I wouldn't want to make predictions from today. A lot would happen between now and 30th December. But what we are seeing currently suggests that the race is too close to call from the poll we are currently doing. Even as we are left with about 200 samples to complete, it is still too close to call. Now, there are people who are undecided at the moment who may tilt the race. But we have to see what will happen on the ground from now till 30th December. What the campaign will be on the ground, what resources will be poured into Kpandai. And I think we are in for a photo finish on this one.
Photo finish, that's interesting. And I mean, we put under infographics there where we've extended it to 2,000. If we extend it to 2,000, then it's not the 2-2 that we indicated. It becomes 4 times since 2000 for the NDC, and then 2 times for the NPP. Photo finish. So Musa, maybe before I come into my in-studio panel, if you were consulted by any of the 2 political parties as the person with the ear on the ground, what do you think would be a clear message for the NPP to be able to tilt to their side, and what do you think would be a clear message for the NDC to tilt to their side? Okay, right. We'll come back to Musa, DANKWAH. Enoch.
On the fact that we need to check.
I think he's back. Hello, Musa, can you hear me? Okay. So viewers, I mean, if you check and again, I'll ask for the infographics from 2000 to be placed on the screen for us to see. So if you check from 2000, like I indicated, there was NDC. 2004, there was NDC. 2008, there was NDC. Then MPP came in strongly in 2012, 2016. Then NDC came in 2020. And then the NPP came in, but has now been, the results have been cancelled. And so that seat, as of today, is vacant. So who will fill Kpandai for the 2024 elections? Why is the MPP, for want of a better term, afraid to go for this rerun? It's your seat. The people who voted for you are still there.
We are never afraid of going into an election. For the purpose of every political party is to win elections, political elections, and get the opportunity to govern. So if you are a political party and you decide that you are not going into a political election where the legalities and the constitutionality of that election is such that it is not an unconstitutional conduct, then it means that you are not satisfying the purpose upon which you were established, or your establishment mandate as a political party. Because there is no political party that goes for contracts to execute road contracts, or to build schools, or to sell in the market, or to do any other thing, apart from campaign to be able to get the mandate of the people and to get the opportunity to serve the good people of this country. Our position is that the Clerk of Parliament, his action, communicating to the Electoral Commission as to a vacancy with regards to the Kpandai seats, was premature. Because the time-held principles under Article 99 of the Constitution that places the burden as to the declaration of a vacancy in Parliament to the High Court was not completely extinguished, had not completely extinguished, because Mr. Matthew Nyindam has triggered his right of appeal under Article 99 too. And once Article 99, the challenge of Article 99 is completely extinguished, there cannot be, you cannot have a valid constitutional right to say a seat is vacant in Parliament, except where a member of Parliament passes, that we are all aware that the person has died and there's nothing to bring the person back to life. But on the matter of an electoral dispute, where the respondent in the petition has served notice that I'm climbing up to the appellate court under the circumstances, he has even climbed a bit higher, a step further to the Supreme Court on a judicial review application, seeking another certiorari to quash the decision of the High Court Tamale Quorum Justice, what's his name? Upon it, the Clerk of Parliament has been duly served with the court processes. And I can tell you on a statement of fact that lawyers for Mr. Martin Nyundam has filed an application for committal for contempt against the Clerk of Parliament for his conduct. And we believe that sometime in January, the application will be ripe to be moved. And we await the decision of the court on that. KOJO, the time-held principles in the Amu case, they are also West Wogon. They are also West Wogon matter. The Nimakan, the Willensi Parliamentary Affairs. In that case, my learned uncle, Alaji ABF Husseini, was a lawyer in that matter. The Nimakan matter has been that until the Article 99 challenge, 1, 2, is completely exhausted, you cannot be said to have a valid vacancy in the House of Parliament. Because let's read what Article 99 1 says. That the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of Parliament or the seat of a member of Parliament has become vacant, or a person has been validly elected a speaker. Let's go to the 2. A person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal. A notice of appeal has been filed and Parliament has been duly served. So once you are put on notice, what is the position of law?
It doesn't stay anything from going.
Again, a stay of execution has been validly filed. The application has been validly moved. The court will make a determination, I think on the 18th of December, whether or not to grant the stay or not. So it means that upon the combined effect of Article 99 1 and 2, can this be said to be a vacancy in the House of Parliament? And really from the time-aged principle, in the Ayawaso West Wogon matter, there are more cases. And in the case of the irregularity parliamentary affairs, Nimakan versus what? Zakaria matter. It is trite. The Jatikuesin case, what happened? It went through the same procedure. And you see, the principle that my learned brother was postulating here, that we should be principled. In the days of old, in the Jatikuesin matter, what was their position? Did they go through Article 99 completely before the said determination and declaration of vacancy was made, or before the notification of vacancy was made? That is yes. Why in the case of Martin Nyundam, where a valid notice of appeal has been served, where there's an allegation that even the court had no jurisdiction in that matter, because per our laws, once the parliamentary resource is gazetted, once it's gazetted, an aggrieved party who is interested in mounting a petition has within, or ought to file the petition within 21 days after the Gazette notification has been issued. When was this petition mounted? Was it after the 21 mandatory dates stated by law? That is why the applicant has gone to the Supreme Court praying for another certiorari to quash the ruling of the Tamale High Court on these grounds.
Why was that not raised as a
Parliament has been duly served. Parliament has been duly served.
Was it a strategy to just hold everything going all the way to...
Parliament has been duly served. In any case, granted Agwendo that even the petition was filed within time, as of right, without the leave of the court. What was the prayer of the petitioner before the Tamale High Court? Was it in respect of some 41 or 51 polling stations or it was in totality of the whole electoral outcomes.
I appreciate the fact that the judge is clothed with authority to even go beyond what the person is praying for. If the judge believes...
It's a matter of judicial review, because the court settles matters in dispute.
Yeah.
The court settles matters in dispute. So the judge is a busybody. That he goes, he acts in matters that is not before him.
No, go on.
These are matters clearly before the Apex Court of the Republic.
Okay,
and
so understand.
On 16th.
So land for me.
On 16th, we are going back to the Supreme Court of the Republic of Ghana on application for judicial review, and we'll hear the outcome from our law lords. The application for committal of contempt against the Clerk of Parliament has also been duly filed. The notice of appeal pursuant to Article 1992 has also been duly served. And clearly, as a law-abiding political party, like a new patriotic party, we have demonstrated within our might and our strength that we believe in the Constitution of the Republic of Ghana and the laws of the Republic of Ghana. Right. So we will not do any act that is an upset, that's an aberration to the laws of the Republic of Ghana. Okay. That is our position.
So I understand MUSSA DANKWAH is back, so I'll ask him that question. I think that's my last question for him. MUSSA, welcome back. So I was asking, gentlemen, I was asking that being a person we consider as the ear on the ground, if you were to advise the NPP, what would be that message you would give to them to be able to sway voters to their side? If you're advising NDC, what would be that message you think they should give to be able to sway people to their side, being an ear on the ground?
Look, we try not to offer any advice for fear of being in conflict. But if I was an MPP, I think what I would do is to tell the people that we need to keep the government in check. We don't need to give them more seat than they need. We have to have a voice in Parliament and to be accountable, or to help hold them accountable. But what happened in the Parliament last week probably has damaged that kind of message, because it didn't go down well with the people the way Parliament scaffolds broke. And people probably will be very difficult to convince them on that basis, because you have not used that number that you have in a way that people saw it to be civil. For the NDC, it's one thing. You know, I don't think they need that seat. Sincerely, I don't think they need it. But for the people who always want development, they always want to look at who can bring them development, and indeed who can champion the needs of the constituents. And I think that is the tangent they will go as they did in Akutia and other places. And that is, I think, from my point of view, how they approach them. For MPP, I think if they win it, it will be because the candidate they have is a very good candidate. But the brand of the party will not help the candidate.
Okay, I'll push you one more time. You're already laughing. Which of the two political parties, as of today, is strong or stronger in Kpandai?
If you look at the data we have today with regards to the direction of the country, 62% of people in Kpandai believe Ghana is headed in the right direction. And about 61% of the people are saying the Mahama is doing very well. And over 51% are saying that their living condition has improved. So these are the sentiments. Which party's era is giving them this feeling? Certainly it's NDC, and that will mean that NDC is stronger.
Thank you, Musa. Thank you very much. If anything, I'll come back to you, but thank you very much for your time. Right, James, 4 minutes. 4 minutes.
Okay.
Kpandai.
Yes.
What does NDC need this seat for? You already have. You've won it 4 times already. This one that is added, MPP has how many? Is it 77 in Parliament? MPP. 60. I mean, MPs.
Oh, now they have about 86.
86.
Yeah.
And you are reducing it further.
Again, I'll go on a matter of principles. He cited principles as well.
It seems
There
to be
are
a
laws-
principled morning.
There are laws governing how elections should be conducted in this country, right? There are laws strictly governing that. Now, if electoral officials decide to subvert the law, instead of going through due process, they decide to subvert it, any party who is offended by that can go to court and challenge it. So if there are grounds, just like the MPP did when immediately after the 2024 elections, they've been in court fighting for seats, claiming that results were not fully declared. And so they were in court for months, including Ablikman North, is this North or South? Ablikman North, I think so. Yes, yes. If there are grounds for that, it should happen. And so for this particular one, the judge, after going through all the proceedings and the evidence that have been placed before him, came to the conclusion that indeed, for the polling stations that have been challenged, there's a ground for it. And for that matter, the election is invalid. It should be done again. The judge is just applying the law.
Okay.
And anybody is entitled to disagree with that.
So the ending. So what the judge or what the people took to court were 41 polling stations. But the judgment is a rerun of the entire constituency, not the 41. And that's what some people, in fact, that's one of the reasons why the NPP and then the former MP is contesting that without 41, even if it's run, and then the NDC wins, it will still not overturn the results. Enoch, is that the case? And so by extending to go to the whole constituency, it's actually giving the NDC an undue advantage because now you are spreading your wings. What's your take on that, James?
In fact, the principle is that when the judge cannot go beyond what is put before him or her.
Yes.
Right? That is the principle. We all know that. Let me say that I'm not fully privy as to what exactly happened in this matter. Okay? MPP can say what they want to say, NDC can say what they want to say. My view is that if they believe that the judge's decision is not founded in law, or the judge went beyond the remit that is given to him by the parties before him, they have a right to challenge it, and they have challenged that. The problem is, does that challenge alone mean that the people should not be represented? No. As far as the declaration has been made by that judge that the election was invalid, it should be rerun, that is the law. That is the law. Until that is overturned by a higher court, Court of Appeal, Supreme Court, that is the law as it is. The fact that you filed an appeal does not stay anybody from performing their duty, right? So if the clerk, by law waited for 7 days for the automatic stay to lapse, and there has not been an order of a court staying Parliament from execution of that order, it is the clerk's duty or the Speaker of Parliament's duty to inform the the electoral body that a vacancy exists in Parliament. The MPP knows what to do in order to stop that election from happening. Disrupting Parliament is not part of that. That disgraceful conduct in Parliament is never part of that. That is not democracy. That is hooliganism. And as I stated earlier, these are the kinds of conduct that are creating insecurity in the sub-region. That is causing people to take the law into their own hands and try to subvert constitutional rule. That is what they are doing, constantly creating the impression that there is tension, there is division, they are being oppressed, and sowing seeds of discord and negativity in the minds of their supporters to rise up against the regime. That is not fair to all of us. So they know the law. The Electoral Commission can be injuncted from going ahead with that election. And I'm aware that they filed different, applications everywhere to stop that process. Why don't they focus on that? In any case, if at the end of the day, the Supreme Court says that the judge was wrong and overturns the election, Kpandai goes back to them. You get it? So the matter is, the principle is that once there is an election to be run, the people deserve representation.
Right.
So the NDC will contest it.
Okay.
And they'll win. they know the NDC will win.
You mean we will win?
They know the NDC will win.
But the NDC?
Yeah, of course, that's what I mean.
So say we, don't say
we will win, yes. We will win. You get it? That is what they are afraid, because AFOAKWAH is just... Oh, are you sure?
AFOAKWAH
is just
it's a constitutional aberration. It's an absurdity.
No, it's not.
That ought not to be entertained.
It's not. It's not.
It is.
So
it's not. Let's follow the law. Let's follow the process.
Clearly it is.
The case being made, or in fact the reason why the NPP MPs or the minority behaved the way they did was that in the case, and I think lawyer AFOAKWAH rightly referenced it, in the case of Jachi question, when before his seat was declared vacant and the clerk wrote to the EC, they had to go through the process. I think he even made an appeal. The appeal was heard, and it was when he had exhausted the process that at this point it was said, okay, now we can declare the seat. So why is this case different? Why is this case, the seat being declared vacant, even though the former MP actually is challenging the decision by the High Court?
I think it's simple. The thing is that does the Yechikwesin incident create a precedent? Is it a precedent for binding anybody? Because my learned brothers are aware of the position of the law, and James evidently referred to that. The thing is that the judge says, go and rerun the election in the constituency. That's a directive. It's an order of the court, which is executable. So by filing an appeal at the Court of Appeal, and also filing a judicial review application at the Supreme Court, these are processes that have not been heard. And the position of the law is that, you can't just stop constitutional bodies from undertaking their due responsibilities unless there's an express order from the court. So the skirmishes or the infightings in Parliament, I think it was needless. And sometimes you wonder, it was even, the commotion was caused by people who are several years, who have been practicing law for several years. These are people who should know what the position of the law is. And when you file, like James said, when you file an appeal, there's a statutory 7-day automatic stay of the judgment. So it won't be executed. But beyond that, must Parliament say because there is an appeal pending before the court, Parliament will not fulfill its work? Parliament has a responsibility that the moment a vacancy exists, notify the electoral commissioner or the electoral commission, and then the commission has a responsibility cut out to conduct elections. So sometimes the thing is, sometimes you laugh when some of these things play out, and you ask yourself, is this a way we build a democratic institution or a democratic country? The Supreme Court has said in several cases that until there is a pronounced court order, constitutional bodies can go ahead with their responsibilities. And I understand it may create huge situations. And let me acknowledge that this is the position of law. Should it be the case? I think there's an issue with the Constitution. That's how we are all seeking to amend. Because some of these things, if the framers had been clear that where there is an issue that is pending, that is before an appellate court, any other maybe future incident or subsequent actions should be stayed. Some of these things there should have been statutory or constitutional provisions governing that. But currently we don't have. That's why the judges have prescribed, have made this pronouncement. So judges So now we are operating within the work, or let me say we are operating within the determination of the judges. And Kojo, let me acknowledge that one, if the stay of execution is granted, and I'm happy if already they've moved the application, the judge is yet to give his decision on the 18th of December. So we have 18th to 30th December. I think we have some days. Just that, you know, the Electoral Commission may have expended some money in preparing for the election. But that is the constitutional situation that we have. So and so long as it is the taxpayers' money, they should go ahead.
Let me give you an example. I think a few years down the line, the Electoral Commission was going to conduct a district assembly election. I think there was some issue regarding that. And Honorable Akpenyumakin went to court and stopped that process. Despite the fact that a lot of money was spent in getting ready for that election. Yeah. You get it? No. So it's some of those things are like hazards we have to
solve. No, that's what I'm saying. That's a constitutional crisis that we have had. We have to work with. And Kojo, you see, I said that if the election is conducted and Matthew Yindam is pronounced to have been democratically elected, the results, I mean, to render it to create a situation where we have 2 members of parliament. But like, I mean, it will create serious exceptional circumstances. But I'm happy that both the High Court and the Supreme Court will have their say before 30th. But then the MPP, my advice to them, go ahead and campaign.
They are there, they are doing it.
Because that is what you need to do. You need to go ahead and campaign and subtly pursue these legal matters. But don't, I mean, put all your hopes in these legal disputes. I mean, the issues before the court. Don't put don't hope that it will work out 100%. Go and campaign. If you end up getting, I mean, if the decisions do not go in your favor, you are on the ground campaigning to retain your seat. I think this one, you know, let's not fight over this. This is legal and it is permissible. Okay.
Doc, let me come on the political science angle. What would make an opposition political party position, or what can they do to position themselves as the party of choice in such an election, considering that they won at the point where whoever was voting did not know who was going to be president? Now the person knows who is president. The person has seen what is happening, like MUSSA DANKWAH indicated. What would make an opposition party still feel too confident that it can win this?
Okay, Kojo, thank you very much. I think before I address that, let me just fill in a little gap
go into the law,
from what they have said. Yeah, because I read something, especially on this matter, the at least Rule 20, that is CI 19. Okay, and then that CI 19 has been amended by CI 132. 132. So if you look at it, it says that 7 days is automatic, mandatory. Okay, but if that elapses, it is only after a court has granted another. Because if you look at it, it says that that's the new rule 27.1 C1 that an appeal shall not operate as a stay of execution under the judgment or decision appealed against unless the court otherwise orders on an application made to the court by motion on notice. So it means that when you even file the notice, or even if you appeal, it doesn't necessarily say that automatically. It means that nothing can be done. So that's where I agree with him. I think that this one is there.
Even exactly is there. The application for stay.
Yeah.
On the party.
Yeah.
Does not.
But the only thing is that when you go through, and then at the end of that, it is granted. That means that a lot of money.
We are hoping that by 18th, all this will come.
But so it means that in that case, whatever the clerk to Parliament has done, in my view, there is no problem with that. No. There's no problem with that.
I think in this case, because it has nothing to do with the people's representation, so it ends at appeal. It can't go to the Supreme Court.
The Jimakan case.
Yes.
It terminates.
So
the other problem is that if you look at the Nyemekan case, it went through that he was in parliament through the period, right? Yes. But maybe at the time, maybe 132 was not there. It wasn't there.
No, it wasn't there.
It wasn't there. So, because that was 2020. So, all right. So, in terms of what the, like, for example, the MPP should, do, how they are going to position themselves, right? It's a difficult situation. But I think that once, they are of a firm belief that they have won, the 2024 parliamentary election, right? Because if you look at the difference, that is about 53 or so to 46% when you project it.
Yes.
That is very huge. Okay, so if indeed that is the real situation, unless there is maybe something, okay, if indeed that is what has happened, then in my view, they should go and then vigorously campaign. Like I said, you have two things. You are pursuing it legally, but don't leave chance to this. But where where the situation is like, no, we are not going to campaign because we have won it, then especially then sometimes it casts some doubts. Especially also the very day the High Court delivered its decision, that very day in court there, I listened to the lawyer, one of the lawyers, and he said that because they were smart lawyers, when they were coming to court, they prepared the notice of straight away. So my point is, if you were convinced that you have won and everything indicated you are this, and I do not think that you have, and then you went through the process and the parties addressed the court. Okay, so definitely you were convinced about something about the evidence that came up over the. That was my thinking. So in my view, and then. MPP, I think that they have been strategic because there is a fear. He talked about the fact that they do not fear election. The truth, from my perspective, I think that there is a fear, and that fear is well-founded. Because, one, if you look at the recent by-elections, okay, where you have, a government, look at the massive support that NDC is enjoying, the goodwill. If you're going into an election with a party of that, and over the period of 1 year, we have seen the fact is that there have been changes. All right, so people are definitely going to, largely going to say that no, it means that we have to do something. Because now they know the person who has won. And then, in the theories of voting, if you look at all the theories of voting, especially now voters are becoming rational. Rational in the sense that they vote for parties that they believe that will be able to do something. And at the moment, it is the NDC that is in the sphere. So they have everything to. So you realize that if they should go for a rerun, right, that is the MPP sphere. And also the fact that even historically, if you look at, even President Kufuor, the third parliament, okay, from 2004, there were about 7 by-elections. Okay, the first one was, Bibla, Nitiwo, right? MPP won that election. Then they went to Kumawu, right, Bazua. NDC said they were going to teach them a lesson for taking their decision. MPP won that's it. From there, they went to Navrongo Central. John Achille, MPP took that seat. Ada. Then from there, they went to, there was another one in Gumua West. MPP took it. So if you look at the trend, especially that goodwill that parties normally send, it has influence on that. So that fear is there. So if there is a way we can do to avoid any election, then let's take that decision, because looking at the situation, the possibility of us retaining it, even though we won, but there's that possibility that looking at the general mood of Ghanaians, right, it means that anything can happen. Already, they have about, 80-something seats or so. Okay, and then I heard the NDC, some of the NDC officials, national officials, is it MUSSA Kpandai, saying that they still have about some 5 seats that they are targeting. Okay, so basically that is it. And you also asked, my brother here, James, why they want to take another seat. Look, in war, right, you should always do everything to show that you are, decent, because there will be 3 years will be.
No, he's talking about 10.
No, not on this platform.
You see?
No, James,
whether you like it or not,
James,
if it will happen, it will happen.
Don't throw this one on this
3 years time, there will be another election. If they have a member of parliament in Kpandai right now, he'll be able to consolidate that and then to win in the next one. So, no mercy.
on this point, and on the point that AFOAKWAH and James have just said. At the 55th session of the Mediation and Security Council at the ministerial level, that's the Ecowas Commission, the president of the Ecowas Commission made a very important point. I'll read the point 5 and 6. And if even that is all time will permit me, I'll read it because it's important. It says that elections have become a major trigger of instability in our community. Despite the best of efforts of our community to establish constitutional convergence principles and to have a support program for elections in our region in order to safeguard our democratic credentials and stability, we have continued to witness political practices that violate these principles. In the coming days and months into the next year, we will be witnessing elections in some countries. We will also be managing the post-events relating to the coup in Guinea-Bissau and the coup attempt in the Republic of Benin. We also have to negotiate with our neighbors, the Alliance of Sahel States, particularly the terms of our security cooperation as we continue to see the devastating effect of terrorist groups along our borders with them. Another point 6, I'll ask my team to show the point 6 on the screen. It says that faced with this situation, what situation? The situation that comes with our elections, certain proclamations we make. Excellency, it is safe to declare that our community is in a state of emergency because of some of the things we say during elections. Because sometimes you come and hear that people have stolen money and doing this, it creates a lot of insecurity, and that's what they are talking about. It's what they're talking about. For that, the sessions of the Mediation and Security Council should be organized more regularly beyond the 2 ordinary sessions for the next 1 year. The rest is not what, but my main focus is on the first line. Faced with this situation, the situation coming with our elections when we are campaigning, the things we are saying, all this speak about third term and all those things that people are saying. Faced with this situation, it says that it is safe to declare that our community is in a state of emergency. So my time is up. I would not ask my team, my panel to speak much onto this thing, but just an advice to all of us, to them, to political actors, and to everybody, that let's be careful of the things we say until we have, and that's why some people have had an issue with the monologue and the bully pulpits used by some of these investigative bodies when they come on social media to run people down. If we keep telling people that this has been done and you do not follow through to prosecute, you create anger in the minds of people. You create anger in the youth. You create anger in people who think that they also deserve a right to fight for what belongs to them. It ends up with some people wanting to rise and come into our homes to also take what they think deserves them. And we have robbers. It ends up getting people wanting to dig into the ground and take gold. And we call them galamseyers and we want to fight them and they want to resist. It ends up with people wanting to seize power, like what we are having in other countries. Let's be careful and let's be mindful of the things we say when we are mounting political platforms, all in an attempt to want to win power. It's very, very deadly and dangerous. Please, let's pay attention.
And most importantly, in Parliament as well.
So, KOJO.
Gentlemen, today, Daddy Numa is going...
Yeah, KOJO, on what you said on the emergency situation in West Africa, you see, you have rightly hit the nail by the head that there is a theory in conflict studies which is to the effect that frustration breeds aggression. That's the frustration-aggression theory. And there's one that I like so much. It's a greed theory. Greed theory. If you are to go into the occurrences, what occasioned this coup d'etats in several of our West African countries, it's as a result of greed. Political actors seeking 4th term and 5th terms. Political actors seeking to usurp the will of the sovereign people by changing their constitution to suit them, seeking 3rd terms, 4th terms, 5th terms, 6th terms, making themselves think gods. The greed is what has plunged West Africa into this situation. It is not only what we say on political platforms, but what we say on political platforms influences our thoughts and how we want to entrench ourselves in political office. We should know that political office is a transit point. Like William Shakespeare said, that the world is like a stage Human beings are like actors and actresses. You come to perform your part, and when the time is due, you have to depart. If you fail to depart and wanting to entrench yourself in perpetuity, it breeds some of these things.
I allow you because I know you have qualification in that area. But gentlemen across, today is the final funeral rites for Dr. Edward Kofi Omane-Boamah. Today at the Jackson's Park, Koforidua. So today, at the same time, I understand yesterday they agreed for Lumba to be.
Legend.
So today, two great men of the land. So I'll just give. We have only 2 minutes, so 30 seconds. Just a well wish, not plenty talk. Let me start with your AFOAKWAH.
May the souls of the gallant departed rest in eternal peace. Edward Kofi Omane-Boamah did his part for this country, and the way he departed is an act of God, and we pray that may his soul find repose in Almighty God. And with the legendary Daddy Lumba DL, he's made a fraternity proud. He's made a fraternity proud.
The post-death issues of
we are learning from history, and it guides us. You see, before you can get people online, you need to throw some offline. Out of these occurrences, it shapes societal values, and it shapes how we do our things. We should not only see the negativity, we should see the values that are risen out of this.
And my team, if you can get a Lumba song just to sign out.
So let's I think the two of them serve their country well, right? And we wish them our condolences to the family. And then we pray that God will put them in his right hand in eternal service.
Austin?
I think I will just speak to those who are living, some of us who are living. Put your house in order. You get it? So that when you are not there, there won't be a chaotic situation. Put your house in order.
Right. James, one of your...
It's always hard to come to terms with the fact that Dr. Kofi Omane-Boamah is no longer here. And the circumstances under which they went, all of them, is very, very heartbreaking. And so on a day like this that they are doing a final funeral rites, we can only pray that God grants all of them a peaceful rest. As for Lumba, my view is that he has lived his life to the fullest, and I'm sure that he's resting peacefully where he is.
Okay. Right, so...
Let's be guided, state institutions. You see, looking at the heading, Yoko, other law enforcement agencies arrest notorious cyber criminal Abu Treka involved in...
He has been declared a criminal already.
Involved in $8 million romance scam. Yoko, you can do better. How do you declare a person a notorious criminal?
Anyway.
What court has passed judgment on this young man? We should be guided.
Thank you.
His presumption of innocence, Article 19(2)(c) prevails.
Thank you.
Until proven guilty.
On Dr. Omane, the late Dr. Omane-Boamah, my heart goes out to the family. May his soul rest in perfect peace. And to be the greatest musician of all times, bigger than Michael Jackson, in my own opinion, Daddy Lumba, you lived and you continue to live after your demise. Thank you very much. Enjoy the rest of your weekend, and see you next week, Saturday.
Of elevating side chicks over.